I'm Elizabeth Trimm. I'm the managing partner of the Sacramento and Stockton offices. In the Brooks case, it was actually quite a lot of fun in investigating the matter. I represented County of Sacramento. I met with quite a few of the employees in probation, the chief executive officer, basically trying to get a foundation on what exactly happened with Mr. Brooks. In our particular case, Mr. Brooks had a good record, no personnel actions to speak of prior to December 2007. And what happened is he was a coworker had asked to meet him at a Starbucks and advised him that he was the subject of an internal affairs investigation. So it was a very serious matter, and as an employer, County of Sacramento was required to investigate the matter. So he was advised the steps that would be taken, and essentially business as usual. You know, nobody is making a judgment against you. We'll let the investigation play out. Please don't discuss it with anyone, and we'll just let the process roll. So what happened after that is Mr. Brooks came to work, and the person had started the internal affairs investigation was on the same shift as he was. And he was told not to supervise him. It was a direct order. Don't supervise him. Minimize your contact with him, business as usual. He went and complained and asked to be taken off work so he could collect full pay, Labor Code Section 4850 benefits. The employer said, no, this really isn't, we have a big work environment here, shouldn't be a problem. How about this? We're going to change your work shift. You'll now be working the night shift, so to speak. Mr. Brooks didn't like that because in addition to his day job as a probation officer, he went to school at night. So what happened was he ended up filing a workers' compensation matter saying he had a psychiatric reaction to the workplace events. Our defense stemmed around what really was said when this accident took place or the injury was reported. In his particular case, before he obtained an attorney, he had gone to the treating doctor and said that he was having emotional problems because of this internal affairs investigation. So getting a foundation from the medical aspect as well as from the employer, the witnesses we had, are what helped us to provide a defense in this matter. Personnel actions are covered under Labor Code Section 3208.3. Essentially, a personnel action is anything done by management in managing their business. The usual personnel action that people think of or that readily comes to mind is a negative job review or perhaps some sort of demotion, an action that is taken that is going to cause a normal person to be a little bit upset. The intent of the law is to not compensate people for an employer doing their business. So under Labor Code Section 3208.3, a personnel action, or good faith, lawful, non-discriminatory personnel action, if it's 35% to 40% of the cause, can provide the employer with a complete defense to the psychiatric claim. In terms of evaluating the personnel action, this is an area that remains hotly contested despite the Larch case being many years old at this point. In Larch, the definition was limited, so case law has expanded on that. In terms of who decides it, does it go to a doctor? Does it go to a judge? In the Brooks case, it was basically a ping pong match back and forth on who makes the determination. In our case, Brooks, the AME, had determined what the personnel action was. That was part of our defense, was that was inappropriate for a doctor to say what the personnel action is. The doctor is supposed to address contribution so we can figure out if we've reached the 35 to 40% threshold. In our particular case, the doctor included factors that wouldn't normally be considered as part of a personnel action or that would be an effect of a personnel action. In particular, she indicated that because Mr. Brooks did not feel supported by management in terms of the personnel action taken, that should be compensated separately. In other words, taken away from the personnel action, which made absolutely no sense for our case because obviously who's going to have no response to a personnel action? You can't just be emotionless, so that was part of our defense. As far as the personnel action, here it was an internal affairs investigation. So by law, the employer was required to investigate the matter. Mr. Brooks' claim was it was bogus, that there was no truth to the matter. The good news is, in doing the legal research for our petition, is there is a case, Graves, that held even if the outcome is favorable to the person who is the part of the complaint, it still provides a defense. Basically, the law does not want to penalize the employer for doing their job, for investigating something, and be fearful of retaliation in terms of a claim. So as long as the investigation is done good faith, lawful, non-discriminatory, you can prevail. One of the biggest factors in our case is the AME had divided the personnel action and the psychiatric claim into 3 separate categories. First was the complaint itself from internal affairs. Second was the directive or the personnel action itself, the investigation. And third was a feeling of unsupport by management. So by doing this with a third each, the effect was that we have to show 35 to 40%. This put us at 33% and a third. So we were 1.7% short of defending the claim. As part of that, we ended up I ended up proceeding with taking the deposition of the AME and basically trying to show that the decision that she had made was not sound in terms of the lack of support. As far as the trial level, the judge actually decided the case consistent with the agreed medical evaluator and held that we were 1.7% short of meeting our threshold. This is when we started the appeal process in terms of asserting that we had in fact met the 35% to 40% threshold. If you move just a small fraction of the feeling of unsupport, which was basically his disagreement with the directive, we met the threshold, and fortunately the Court of Appeal agreed. As far as the personnel action defense, it's still hotly contested as to what qualifies. Even though there have been many cases on the issue, it continually is expanded or contracted depending upon the facts of a particular case. So it's important that an employer look for the action that took place. In terms of personnel actions, it's always important that you obtain a medical opinion. You can't go straight to trial with just information on your assertion or hunch that the injury is the result of an unfavorable personnel action. A medical opinion is required. The factors are set forth in the Rolda case. Basically, the doctor has to determine whether the injury was the result of a personnel action. From there on, it flows to the legal process and proving your points. Today, personnel actions are still hotly contested. Oftentimes, people are confused on what exactly are personnel actions. It can't just be anything at work. It has to be something done by management. So basically, the easy ones remain disciplinary issues. A personnel file is crucial for a defense, as is the medical records to show the intent of the party making the claim. If you have a case with a personnel action and you're the first point of contact, the best defense is to contact the claimant before they're obtained representation and ask them questions about why they believe they have a work injury. What happened at work? Was it due to some sort of negative job review? Was it due to something that happened at work that they didn't like? Generally, before they're coached by an attorney, you're going to get a more valid and honest response.